Good morning, everyone, and welcome to today's junior programme on property law. I'm Emma Loizou, and I'm going to be speaking today about the Court of Appeal case in Trecarrell House Ltd and Rouncefield.
Morning, everyone. My name is Natalie Pratt, and I'm a new face in Chambers. I'm the junior most tenant, and I'll be talking this morning about the recent Law Commission report on reinvigorating commonhold.
So I'm going to share my presentation now. So, the Court of Appeal case in Trecarrell House Ltd and Rouncefield. This case addresses the requirement on a landlord to provide a tenant with a gas safety certificate, and that's required before a landlord can take advantage of the Section 21 procedure. My focus today is on one of the issues raised in the appeal, which is the obligation on the landlord to provide the requirement prior to a prospective tenant's occupation. Before it can use the Section 21 procedure. So if it has not provided the gas safety record prior to occupation but does so at a later date, does that invalidate the Section 21 notice? So I'm going to start today by looking at the relevant legislative background, which is arguably quite a labyrinth and has numerous overlapping regulations. I'm then going to look at the first instance decision before moving on to consider the Court of Appeal judgment. So our starting point today is Section 21 of the Housing Act 1988, which concerned a landlord's ability to obtain possession of premises that are let on a short hold tenancy agreement on their termination. It's essentially the non-fault eviction procedure. However, before a landlord can give a Section 21 notice, he must have complied with several requirements. And one of those requirements is Section 21A of the Housing Act 1988. So Section 21A requires compliance with prescribed legal requirements relating to the health and safety of occupiers of dwelling houses. And Section 21A, subsection 1, provides that a notice under Section 21 may not be given in relation to an assured short hold tenancy of a dwelling house in England at a time when the landlord is in breach of a prescribed requirement. I've just highlighted that text in bold because it becomes fairly relevant when the Court of Appeal considers the issue. So what are the prescribed legal requirements? Well, some of them are helpfully set out in the Assured Short Hold Tenancy Notice and Prescribed Requirements England Regulations 2015, namely Regulation 2. So what we have here is that paragraph 6 and 7 of the Gas Safety Installation and Use Regulations 1998 become prescribed requirements. And this is the obligation to provide a tenant with a gas safety certificate. Regulation 2, paragraph 2 has caused the main problem here in this appeal, these types of disputes, because it says that for the purposes of Section 21A of the Act, the requirement prescribed by paragraph 1B is limited to the requirement on a landlord to give a copy of the relevant record to that tenant, and the 28-day period for compliance with that requirement does not apply. So this will make more sense as we actually go to look at the Gas Safety Installation and Use Regulations 1998. So for our purposes, again, it's Regulation 36 that we're concerned with. And Regulation 36 is all about imposing obligations on landlords of residential premises to ensure that gas appliances are maintained in a safe condition and are regularly inspected. So there's an obligation on a landlord to check the appliances and flues regularly at 12-month intervals and then to keep records. The prescribed requirements that are relevant for the Section 21 notice are in 36.6 and 36.7. And 36.6 is split into two different obligations. So A means that a landlord has to provide the relevant record of check to existing tenants within 28 days of that check. That's where the 28-day comes into play. And 36.6b is a requirement to provide a copy of the last record to any new tenant prior to occupation. Then we have Regulation 36.7, which is relevant where there's no actual gas appliance in the room occupied by the tenant, but the copy of that record, instead of being provided to the tenant, can actually be displayed in a prominent position. So the result of all of this legislation together is that the landlord must comply with those requirements if he or she wants to be able to use the Section 21 notice procedure and then the accelerated procedure for possession that comes with that. Failure to comply may mean that the landlord is actually restricted to using other grounds for possession. So let's move on to the dispute in Trecarrell. The dispute arose from the following facts. Miss Rouncefield had entered into an assured short-hold tenancy agreement with Trecarrell House Ltd on the 20th of February 2017. And that was for a period of 6 months. Now, the flat that she went into occupation of was serviced by an external gas boiler, so there was no gas pipes or appliances actually in the flat itself. When she entered into occupation, there was a gas safety record that was dated the 31st of January 2017. But that gas safety record wasn't provided to her prior to her occupation. It was actually provided to her about 9 months later, on the 9th of November 2017. Subsequently, on the 1st of May 2018, the landlord Trecarrell sought to serve Section 21 notice and then to obtain possession using the accelerated possession procedure. So the main issue or one of the main issues in the appeal was looking at whether the failure of Trecarrell to provide the gas safety record dated the 31st of January to Miss Rouncefield prior to her entering into occupation prevented the landlord then from serving the Section 21 notice. Now, there was an additional issue that was raised in the appeal, in the Court of Appeal, about a second gas safety record that was dated subsequently to this one, and whether that one had been provided itself prior to the Section 21 notice. And that issue was remitted for determination. But for our purposes, we're just concerned with whether the gas safety record that wasn't provided prior to her occupation prevented the Section 21 notice from being valid. So Ms. Rouncefield defended possession proceedings, arguing that Trecarrell had failed to comply with the prescribed requirements, hadn't complied with the obligation to either provide her with or display prominently a gas safety certificate prior to her occupation. The landlord subsequently argued in the appeals that Regulation 2.2, so let's just go back to this one. So Regulation 2, paragraph 2, removed the 28-day period in respect of existing tenants and the 28-day period for compliance does not apply. But what it also did was that it removed the time limit in relation to the new tenant, so that the obligation to provide the recent gas safety certificate to a prospective tenant was not dependent on it being provided prior to occupation. Trecarrell also sought to argue that Regulation 2, paragraph 2, actually excluded the requirement in relation to prospective tenants entirely, and so made it essentially not a prescribed requirement. And they argued that this was because the phrase is limited to the requirement on a landlord to give a copy of the relevant record and the 28-day period for compliance does not apply, should be read as including only the provision in relation to existing tenants minus the 21 days, because in relation to prospective tenants, there was no 28-day period. So what happened in the first two decisions? So before District Judge Rutherford, he held that the time limit prescribed in Regulation 36(6)b for the provision of the certificate before the tenant enters into occupation was not a bar to late compliance, and so in this case in November 2017. Ms. Rouncefield then appealed that decision, and it came before Judge Carr, and he found in favour of Ms. Rouncefield and held that the late compliance with the regulation prevented the landlord from relying on its Section 21 notice. And he relied on a decision of His Honour Judge Luber QC in Corridon Property Limited and Schultz, and considered that the requirement to provide the gas safety certificate prior to occupation ought to be applied strictly, and so later service or display was insufficient. Now, the effect of Carr's decision and of Luber as well seemingly prevented service of a 21 notice for all time if a landlord had omitted to give it to serve it before the tenant had entered into occupation. And it's a slightly odd result, because if the landlord has in fact undertaken the relevant checks, the premises are safe, and the failure is just in the oversight in providing a copy, then it may lead to the consequence that the landlord would be prevented from all time from using the Section 21 procedure. So the issue went up to the Court of Appeal. The focus in the Court of Appeal was on the effects and was on the interpretation of the effect and meaning of Regulation 2, paragraph 2 of the 2015 regulations. And Lord Justice Patten gave the leading judgment. And he concluded first that, contrary to what Trecarrell had argued, Regulation 2, paragraph 2 does not exclude Regulation 36(6)(b), so does not exclude the requirement to provide the prospective tenant with a gas safety certificate from being a prescribed requirement. And he said there were two main reasons why this was, essentially. So first, such exclusion made no obvious sense in terms of the policy behind the regulations. It was not clear why Parliament would require compliance in relation to existing tenants, but then not allow, would exclude equivalent protection in relation to prospective tenants. It would create a disparity between the two. Second, if that was the way of, if that was what was intended, then it was an odd way to draft the provision. And I'll just go back to Regulation 2. So 2(1)(b) makes no distinction between paragraph 6 in relation to existing and prospective tenants. Whereas paragraph 2, they were trying to argue that that then removed the requirement in relation to prospective tenants. If that were the case, what you would expect to see is that 2(1)(b) only referred to paragraph 6A in relation to existing tenants. Lord Justice Patten concluded that the more obvious construction was that Regulation 2, paragraph 2, referred back to 2(1)(b) and specified the obligation to give the certificate in 6 as a whole. But what the requirement is only the requirement on a landlord to give a copy of the relevant record to that tenant. That's the requirement. So this is his one of his conclusions. So he said, the effect, therefore, of Regulation 2 is to remove the 28-day time limit in paragraph 6A and argue also the requirement in paragraph 6B that a new tenant should be supplied with a copy of the current gas safety record prior to taking up occupation. The obligation uplifted by Regulation 2(1)(b) is, as the words in parentheses indicate, no more than the obligation to provide the tenant with the relevant gas safety record. So I suppose that, for Lord Justice Patten, preempted his conclusion on the appeal on the timings. But he then went on, in any event, to consider the time limits in paragraph 6B in relation to prospective tenants. So these were the conclusions that were found by Lord Justice Patten and Lady Justice King. But just to look at some of the reasons that Lord Justice Patten went through for the basis of his conclusion. He indicated that there would be a disparity in outcome if the rules in relation to prospective tenants were applied so strictly. So if the failure to provide a new tenant with a copy prior to occupation meant that the landlord could never serve a Section 21 notice, then the requirements in relation to prospective tenants were far greater than in relation to existing tenants, where the 28-day limit was explicitly disapplied. And this reference to the disparity was echoed by Lady Justice King in her judgment. And she said that such a disparity of outcome would not fit with the legislative scheme. Lord Justice Patten also looked at what the primary sanction is for a breach of the gas regulations. And he said the denial of the ability to validly serve a Section 21 notice isn't actually the primary sanction. If a landlord is in breach of the 1998 regulations, then that's actually punishable as a criminal offence. And the fact that Parliament had also removed the 28-day limit in relation to existing tenants showed that Parliament must not have intended the requirement to be applied so strictly. Both Lord Justice Patt and Lady Justice King also considered the meaning of in section 21A, and that phrase that I highlighted at the beginning, which says at a time when the landlord is in breach of the prescribed requirement. So you cannot give a valid notice at a time when the landlord is in breach. And Lord Justice Patten noted that that phrase did not specify what must be done to bring the embargo on serving and giving a section 21 notice to an end. It just refers to the time when the landlord is in breach. But there's no clear guidance on what the landlord must do to end the breach. And he reached the conclusion that the remedy, the remedial nature of the breach, could be found in Regulation 2, paragraph 2. So overall, his conclusion was that the obligation to provide the relevant gas safety record to a prospective tenant prior to occupation could be complied with by late delivery. It gives that tenant the information that they need. And his conclusion then is, as a matter of construction, I therefore prefer the view that as a result of Regulation 2, paragraph 2, the time when the landlord is in breach of paragraph 6b ends for the purposes of section 21A when the gas safety record is provided. And Lady Justice King agreed with the analysis of Lord Justice Patten. She noted that all the words in section 21A, at a time when is in breach, that gives no clear guidance as to when the landlord may cease to be in breach, but it indicates that there is something within it that enables him to cease to do so, and that is Regulation 2, paragraph 2, and to give the copy of the relevant record to the tenant. So she thought that the proper interpretation of Regulation 2 recognises that it sets out to achieve an equal outcome to both prospective and existing tenants. And her conclusion is, in my view, so long as the GSR has been provided to either a new or existing tenant before service, a landlord retains his right to use the section 21 procedure, notwithstanding his or her earlier breach of the section 36(6) or 7 requirements. So that was the majority judgment. But we then have the dissent of Lord Justice Moylan, and he arguably undertook a more natural reading of the regulation and reached a different conclusion to the majority. So he considered that within the gas regulations, Regulation 36(6), there were two separate obligations, one that referred to prospective and one to existing, and it was only in relation to the existing tenants that there was this 28-day period for compliance. And although he acknowledged that there could be a disparity of outcome if you read Regulation 2 in such a plain way, and there was a harsher sanction for not complying with the rules in relation to prospective tenants, and there was no clear reason why the effect of the regulation should not be given its plain meaning. So he said, the difficulty I have with interpreting Regulation 2, paragraph 2, as also applying to paragraph 6b, is that it expressly refers only to the 28-day period for compliance and uses the word that requirement. In addition, the two elements, the provision of the gas safety record and the reference to the 28-day period, are connected by the word and. The reference only to the 28-day period and not to the time stipulated in paragraph 6b before that tenant occupies. And the use of the words and that make it clear in my view, the Regulation 2.2 is only referring to the requirement in paragraph 6a. So although there was a strict sanction for the breach of not providing the gas safety record to prospective tenants, that was the effect of the legislation. There was nothing within section 21A or any of the other legislative provisions that provided a sound reason for reaching a different conclusion. So there we have it. That's the consequence of what Lady Justice King described as awkward drafting, a non-unanimous judgment which turns on the reading of parts of the regulation. So the majority leave us with the result that the obligation to provide a gas safety record to a new tenant prior to occupancy can still be complied with by late delivery of that certificate. And in some ways that's, I suppose, a more common sense approach, but there's questions over whether that's at the expense of twisting the wording of the relevant regulation. So some landlords can obviously breathe a sigh of relief from this, but clearly it's not not clear for how long since the government has indicated their proposals to put an end to the so-called no-fault eviction anyway, by repealing section 21. And on the 28th of August 2020, the government announced that they're committed to bringing forward the Renters Reform Bill to abolish section 21, but it's not clear when they're going to do so. So that's Trecarrell House Ltd. I'll happy to answer any questions at the end, but also interested in seeing if anyone else has any views on whether they agree strongly with Moylan's dissent, or whether I think the majority was the correct decision. But I'm now going to hand over to Natalie.
Okay, so I'm going to talk about something that perhaps we missed whilst we were all looking the other way in lockdown. We were thinking about the stay on possession proceedings. And that thing is the Law Commission report on reinvigorating commonhold. And notwithstanding the fact that it probably flew under the radar for most of us, this could actually turn out to be something quite important and something that we're going to have to get to grips with either sooner or later. So for some reason, I can't skip slide. There we go. Okay, so on the 21st of July of this year, the Law Commission published 3 reports. They published one on leasehold enfranchisement and lease extensions. They published a second one on the right to manage, and then this third report on reinvigorating commonhold was also published at the same time. And so these 3 reports, the idea behind them is that their terms of reference were not intended to be neutral. So they were intended to make recommendations so that the law should operate more favourably towards leaseholders. So the general feeling, I think, that the Law Commission unearthed is that, generally speaking, freehold ownership is what we all aspire to. And you can kind of understand that that's probably true because of the security and control that you get with a freehold ownership that you don't necessarily get with leasehold. And so the Law Commission set about making a series of proposals to try and rebalance the law and skew it more favourably towards leaseholders and move some of that security and control away from freeholders and place it in the hands of leaseholders, especially where we have residential units and people's homes being owned on a leasehold basis. The overarching conclusion of the commonhold report, though, is perhaps slightly different. So the overarching conclusion of the commonhold report is that where it's possible to own your home on a freehold basis, that should be preferred to a leasehold basis. And so if we remember that commonhold is a species of freehold tenure, it follows that it's preferable that your home should be held as a commonhold rather than as a leasehold. And we can kind of already see this shift away from residential leaseholds. Say, for example, in the government's announcement that it intends to ban the sale of leasehold houses. So this thinking is already in our discourse, and it's not a completely radical suggestion by the Law Commission. So this all rather begs the question of perhaps, what is a commonhold? And we could all be forgiven for not really knowing what they are because there are so few of them. So at the moment, I think we only have about 20 that have ever been created. But notwithstanding that, they're not a new thing. So they were introduced by the Commonhold and Leasehold Reform Act in 2002. They became a thing really sort of in 2004 when you could actually start to create them. And really your commonhold requires there to be 2 legal structures working together. So the first thing that you have is you have a commonhold unit. And so your unit is a smaller parcel of land or a smaller area located within a larger building. So really your quintessential example is your flat or your apartment. And the idea is that you hold this unit on a freehold basis. So you hold it as a freehold tenure rather than on a leasehold basis that you would ordinarily expect to hold it. The second thing that you need for a commonhold to work is you need a commonhold association. And a commonhold association is essentially just a company limited by guarantee. It's got some special features that makes it a commonhold association, but at its core, it's just a company limited by guarantee. The special thing, or one of the special things about commonhold associations, you can only be a member of the commonhold association if you are a unit holder. So only if you have a unit in the wider building are you entitled to be a member of the commonhold association. And then the commonhold association itself holds the freehold to the building and all the communal areas in it. So maybe things like hallways, staircases, car parks and gardens, things like that. And then this company limited by guarantee is governed by a commonhold community statement. And this essentially operates like an Articles of Association. So it governs the relationship between the unit holders and members of the association, and it also governs their relationship with the association as a whole. And so the structure looks fairly familiar. It's something that we're kind of used to already seeing. We're used to leaseholders coming together, forming a company and purchasing the freehold of their building. But the thing that's really different about the commonhold is that freehold tenure of the unit. It's not being held as a leasehold. There's no landlord-tenant relationship here. And commonhold, whilst it might appear a little bit radical to us, it's not really radical at all. If you go to other common law jurisdictions, you'll see something very, very similar. So you'll see either condominiums or strata titles. And I think the Law Commission research suggested that in 9 of the 10 most expensive cities in which you can purchase property, actually in 9 of those 10, if you buy a flat or apartment, you'll buy it either as a condo or strata title. The only exception, I think, was Hong Kong, and that's probably easily explained by Hong Kong deriving its land law from English law. So this isn't completely radical, and it's something that is familiar elsewhere, and really we're just trying to keep up with the times. So what really then are the benefits of commonhold? Why is the Law Commission suggesting that we should all rush out, reform commonhold and try and buy them? Well, the first thing is that it does give you freehold ownership of your home. And that really does 2 things. It places the financial value of your home in your hands, and it also gives you more autonomy and control over your home. So if we think about the financial value point, we all know that at some point in time, your leasehold is going to become a wasting asset. We know that once it starts to run down and you only have, say, 80 or 60 years left, it can be very difficult to secure mortgage borrowing against that property. It can be very difficult to get people to purchase your leasehold because they can't get a mortgage against an 80 or a 60-year lease. Or you might find that you have to go to the great expense of extending your lease. And once it starts to run down, that can get pretty expensive. So we're taking that financial value and putting the control back into the hands of the homeowner. The other thing that the freehold ownership does that perhaps leasehold doesn't is it does give you more autonomy and control over your home. Okay, so fine, you still have to comply with things like planning control. And there still will be rules of the Commonhold Association that you have to comply with. So you still have to comply with that Commonhold community statement. But ultimately, as a unit member or as a member of that association as a unit holder, you get to have some control over those rules. You get to have some say over what they are. So it just gives you more autonomy and control over your home. It's probably also worth remembering, as I'm sure we haven't forgotten, we've all spent a lot of time in our homes over the last few months. We probably will do again fairly shortly by the looks of it. And so most people probably wouldn't find it too objectionable to say that really what we should be doing is placing as much control and autonomy in a homeowner's hands as we possibly can. One of the other big benefits of commonhold then is also that you don't have that landlord-tenant relationship that you do in a leasehold. And then that means you don't also have all the things that come from that leaseholder relationship. So you don't have things like ground rent. You don't have the risk of forfeiture in the same way, for example. Okay, fine, you still have to make contributions to the Commonhold Association. But again, as a member of that association, you have the opportunity to set the rates of that contribution and also what those contributions are used to pay for. So it just gives you a little bit more control than you perhaps would ordinarily have in your leasehold relationship. And the other really good thing about commonhold, perhaps, is that it's actually specifically designed to facilitate collective ownership. The leasehold was never really designed to facilitate large blocks of flats and managing the relationship between leaseholders. We've made it work for that purpose, and often it works fairly well. One of the reasons why we use it is it enables us to enforce positive obligations amongst leaseholders and their successors in title. We can't necessarily do that with freehold, or we can't do it quite so easily. But you still have that landlord-tenant relationship, you still have that inequality in the balance of the power. And really that makes it inherently unsuitable for long-term residential ownership. So all rather begs the question that if commonhold is so good, why did it fail to take off first time round? There are lots of reasons why, and I'm definitely not going to go through all of them. I've sort of picked 3 made them quite broad and shoved some extra stuff under these subheadings just for good measure. So the first headline point, I suppose, really is that it's actually quite difficult to convert, at the moment, a pre-existing leasehold relationship into a commonhold. At the moment, if you want to convert your pre-existing leasehold into a commonhold, you need the unanimous agreement of absolutely everybody in that building. So you need all of the leaseholders to agree, you need the freeholder to agree, and you also need all the mortgage lenders who have security over the flats to agree. And you can imagine that in all but the smallest of developments, that's going to be pretty tricky to achieve. And even in the small developments, that could be quite tricky. You can easily see that maybe a freeholder will hold out because they want a sizable compensation package for losing their interest. You can see that perhaps mortgage lenders might be a little bit eggy because they don't really understand what a commonhold is at the moment. So it could be quite difficult, and it is difficult to obtain everyone's consent. So really, it's only viable to use a commonhold at the moment if you're putting up a new development. The other reason, perhaps, why commonhold hasn't taken off, it's quite inflexible. As the rules stand at the moment, it's not the most flexible structure in the world, and there is this accusation that perhaps it adopts a one-size-fits-all approach. It doesn't really account at the moment for mixed-use development, so it doesn't really allow for the nuances that might occur where you have, say, commercial units and residential units in the same building. At the moment, all the members of the association, so all the unit holders, whether commercial or residential, will all pay into the same collective pot. And that money is then used to finance the building. So you might end up subsidising somebody else, and you can see that people might feel aggrieved at that. So, for example, if you live on the ground floor flat and you have to pay exactly the same amount into the collective pot with someone who lives on the 20th floor, and then you find out that pot of money is being used to service the lift, you're probably not going to be too impressed with that. And at the moment, the commonhold scheme doesn't really allow for those sorts of nuances. And it also doesn't really allow for nuances in decision making either. So at the moment, every unit member, also every unit holder, is entitled to vote on everything within that commonhold association. So again, if you don't have the rights, or if you don't have the ability to park your car in a parking space, that isn't a benefit that comes with your unit. Nonetheless, at the moment, you still have the opportunity to vote on matters that affect the car park. So you might say, well, actually, no, we're not going to resurface it, or something like that. And then you can start vetoing things that you don't particularly want to happen because they don't affect you. The third big reason perhaps why commonhold didn't take off, and it links to the other two, is this problem with financing commonholds. It's very difficult to see how you might finance a conversion to commonhold if, even if all your unit holders agree, one of them perhaps can't pay. That freeholder will need compensation for giving up their freehold interest. They're going to have to be paid for that. And if you have some leaseholders who, even if they wish to convert but can't pay for it, we need to have a mechanism to deal with that. We also, as I've mentioned, need to have a mechanism to make sure that unit holders are being fairly charged, so really that you're only paying for the services that you use. But also the really big thing about financing is mortgage lenders. So at the moment, mortgage lenders don't really understand what a commonhold is. And at the moment, we're in a pretty conservative financial climate. The mortgage lenders aren't just going to be lending on anything. They're going to be taking quite a conservative approach. So they want to know what these things are. They want to make sure that their security is safe. Someone needs to explain this to them. And it's also important for the mortgage lenders that we have a really robust system of financing commonholds. There's a real risk that your commonhold association could go insolvent. If it goes insolvent and it doesn't exist anymore, you're then going to have lots of flying freeholds and all the problems attached to that we're already anxious about. And mortgage lenders aren't going to like that. They're going to want to make sure their investment is safe. So with all of this in mind then, what do the Law Commission say? What do they propose to encourage us to rush out and buy commonhold? Again, health warning, not looking at all of the recommendations. There are 121. I'm probably looking at 5. I would bore you to tears if we went through 121. Some of them are quite technical. The first thing then for conversion, the big suggestion or the big proposal is that we don't need unanimity. So we shouldn't expect unanimous agreement of everybody in that building. in order for a conversion to take place. And crucially, the Law Commission are proposing that we don't need freeholder consent anymore. You can see that that might generate some problems because ultimately the commonhold association still needs to acquire the freehold of the building. And if the freeholder's not playing ball, that might be quite difficult. So the solution to that, the Law Commission say, is that you should be able to acquire the freehold, or the commonhold association should be able to acquire the freehold through a collective freehold acquisition. So the sort of mechanism that we're already used to through the enfranchisement provisions. And instead of making this a two-step procedure where you have to acquire the freehold and then convert it, the Law Commission is saying, well, we should have a streamlined acquisition and conversion process. The other point on unanimity, the Law Commission say that we should only require the consent of 50% of leaseholders. So again, very similar to the collective freehold acquisition provisions. And we know that that's already difficult enough to achieve in some circumstances. So you can imagine if you put it any higher than 50%, we're probably just going to be in the same pickle that we are now. And crucially as well, Law Commission propose that we shouldn't have to look for the consent of mortgage lenders on a conversion. So the Law Commission are proposing that the government should work with mortgage lenders to ensure that they will automatically accept that commonhold and their security over that freehold tenure. And you can imagine actually that if someone explains this to the mortgage lenders and we assure them that the risk of a commonhold association falling into insolvency are fairly limited, they might find this quite a positive change. They are probably going to be more, or they're probably going to be fairly happy about having a security over a freehold property, whereas previously they had security over leasehold, because there's just going to be a lot more security and control. You don't have the same risk of things like forfeiture. So you could see that it might be quite easy, if explained properly, to get your mortgage lenders on board. We still, though, have to deal with this problem of non-consenting leaseholders, especially if we're only looking for 50% of them to consent to a conversion. So there are two options, the Law Commission say. The first option is that we can leave these people as leaseholders. So if you don't consent, that's fine. We'll leave you as a leaseholder. And that freeholder, that landlord-tenant relationship will continue. It'll just continue with the commonhold association. Or option two is we could force you to convert to the freehold. The Law Commission say that we should really prefer option two. And we should prefer option two because it enables the commonhold structure to work as intended from day one. You don't have this weird hybrid of some leaseholds in a building, the rest of it's commonhold, and all the problems that that might bring. That in itself, though, will raise two issues. If you are forcing someone to convert to a commonhold, it's very difficult to imagine that you should be able to force them to pay for that. So that's one issue. And the flip side of that as well is if we're not forcing you to pay for it and your leasehold is suddenly upgraded to a freehold, that's a fantastic windfall that you're going to enjoy. So the solution to this, the Law Commission say, is that there should be government financing available for all leaseholders who are converting, not just non-consenting leaseholders, but all leaseholders. And that financing will be secured against the property, against your freehold unit, and it will rank behind any pre-existing mortgage. So that's the way that the Law Commission says we can get around some of these problems that currently exist with conversion. In terms of the issues of flexibility, there's a suggestion that perhaps what we should do is create sections within the commonhold. And this could be especially useful if you've got a large or a mixed use development. And the idea of sections is kind of what it does what it says on the tin. There are different groups of people within the building who have a shared interest, and that shared interest might be slightly different from the others. And those people can come together and they can make their own decisions about financing, and also they are the only people who are able to vote on a particular issue. So, for example, if a small percentage of the unit holders are able to use the car park, those people can come together, form a section, they can decide how they finance the car park, how that money is used, and also they are the only people who have an entitlement to vote on car parking issues. Sections could be governed by committees, or they could have their own committees, And also, crucially, they could have their own bespoke rules. So there could be sections of that commonhold community statement that only apply to sections and not to the commonhold as a whole. And one of the other key things that the Law Commission say is we should be able to create sections either at the outset, so maybe the developer can create the sections, or it should be possible to create them at a later date. Nearly there. A couple of other things as to flag that might be quite important for us, especially from a practical perspective. Compulsory reserve funds. So at the moment, it's actually optional to have a reserve fund in a common hold. And the proposal is that actually these should become mandatory. And you can see that that's probably a sensible idea. This will help protect the solvency of a common hold association. And insolvency is probably going to be something that we really need to keep an eye on in order for common hold associations to work properly. So if we haven't got an emergency fund and all of a sudden we need to change the roof, that could have huge financial consequences. And if you have a common hold falling into insolvency and that common hold association is wound up, again, as I've already mentioned, we have this issue that we're going to have lots of flying freeholds. And if there's a real risk of there being flying freeholds, that will have a knock-on effect as to whether mortgage lenders want to get involved in these developments. And they'll probably take quite a negative view of common hold as a whole. So compulsory reserve funds are probably quite sensible and will really help protect the solvency of a common hold association and ensure its long-term survival. And the other thing that we probably need to keep an eye on for our purposes are the dispute resolution procedures within common hold. So at the moment, your community common hold statement should provide or make some provision for ADR. At the moment, it should only, or the rules state that it should only encourage unit members to think about ADR. The Law Commission say that actually we should make this a little bit stronger, and we should say that ADR must be used if it's appropriate and proportionate. There's also a suggestion that if one unit holder has to pursue another for some breach of the community statement, then they should be entitled to indemnification for their costs. And also, again, something that's probably really important for us is there's a proposal that we should remove the dispute resolution jurisdiction from the courts and place it with the tribunal. So just making the process a little less formal, hopefully having some positive impact on the costs of these disputes, and also maybe increasing unit members' engagement with the dispute resolution process rather than requiring the instruction of lawyers all the time. So in conclusion, what does all of this actually really mean for us? It probably means two important things. If common hold really is going to become more prevalent, and it really is going to be the preferred tenure for communal living arrangements, we're probably going to have to get to grips with it and how it works and some of the technicalities. The second thing that it really means for us as property lawyers that we might not always be particularly comfortable with is we're going to have to get to grips with corporate structures and how they work, because your common hold association is just a company limited by guarantee. Okay, it's got special things about it, but at its core, it's a company. And that will have some impact on the way that we deal with common holds. So we're going to have directors' duties that we need to keep an eye on. So we need to make sure that we're familiar with those and how they run through the Companies Act and what they actually mean. There's going to be some formal requirements that we need to be aware of, so the various documents that need to be filed at Companies House, for example. And the Law Commission do expect that there will be professional managers in this building. So they do expect that directors will appoint professional managers to do most of this, but nonetheless, it's something that we need to be aware of. And finally, something I've already said a couple of times, something else that we're going to need to keep an eye on is the solvency of these common hold associations and protecting their long-term position as a property tenure. So I think probably that's a whistle-stop tour of common hold and what it might mean for us.
How long is it, do you think, until these commission proposals will become law?
Well, I mean, in reality, it could be a while. So if we think probably the last really big thing that the Law Commission did for property lawyers was in 2011, and that was the Making Land Work report. And this was the one that recommended that we should have positive obligations that attach to land. So they called them the land obligation. That found its way into the Queen's speech. I think the speech that happened immediately before the Brexit referendum. So it took, nearly 5 years to get to that stage, and now it's all gone rather quiet. So it rather depends on what the government of the day have got going on. At the moment, they've probably got quite a lot going on.
Yeah, imagine so.
So it could be a while, but given that it comes as a series of 3 reports and it's quite in vogue, it seems to be along the lines of the discourse that everyone's pursuing at the moment. It might come forward sooner rather than later. It's a possibility. And there is already that pre-existing legal structure in place. We're just reforming it. So, I mean, that's if you're only amending something rather than bringing in something entirely new,
quicker,
that might be useful.
might be speeding things up. Excellent. With regards to Trecarrell, my understanding is if a landlord has not served a gas safety certificate prior to the beginning of a tenancy, this cannot be rectified by attaining a gas safety certificate prior to serving a Section 21 notice. It's only applicable if the landlord has obtained prior to tenancy being entered into. Thank you. So from Trecarrell, the approach from the majority decision seemed to say that if the gas safety record, even though it hasn't been provided to the tenant going into, who's just about to go into occupation, if it hasn't been provided to them prior to occupation, then as long as that gas safety certificate is given to them at some point prior to the Section 21 notice, then they can still rely on that Section 21 notice. I think that answers your question. Thank you all for joining us. We hope you had a good Friday morning and enjoy the rest of the weekend.
Thank you.